This week on the Empower LEP Collaborative Podcast, we get to sit down with Brian Sciacca, a special education attorney with over 20 years of experience. Listen in as Jana and I quiz him on his knowledge of all of things special education law. And honestly, he's just a great guy to talk to, very kind man who taught us a whole lot. So listen in so you can learn too. All right. Well, welcome back to another episode of the Empower LEP Collaborative Podcast. We're your hosts, Bethany Zoller
and Jana Parker.
And today we have a special guest who's not an LEP, but we let him on the show anyways. And that is Brian Sciacca. Thank you so much for being here, Brian.
My pleasure. Thanks for having me.
Yeah. So Brian, you're not an LEP. So will you tell us about what you do and where you do it?
Yes, I'm a special education attorney. I have been for 20 years, and I practice all over the state of California, but my office is in Laguna Beach where I live. And yeah.
Okay. So 20 years.
20 years. Yes, it's gone by very quickly, and it's been great. It's a fantastic place to work, and yeah, it's a really rewarding profession to be in.
Have you always done special education law, or did you do any other areas?
I've always done special education law, but I dabble in other areas. I do some civil rights work, and
Awesome.
Being a solo practitioner, I'm also able to help family with random things that come up. And I really enjoy that part of my practice, being able to help friends and family with just novel legal issues to them. But special education law has been my primary area of practice. I actually worked in a special education classroom before I went to law school. So that's how I ended up in special education law as a career.
That was going to be my next question, is how did you pick special education law? So what was your experience like in a special education classroom?
Yeah, well, I was a water polo and swimming coach. I played water polo and swam in college, and I thought I was going to be a teacher and a coach. So as I was working on my teaching credential, I worked in a special education classroom. Back then it was called Resource Specialist Program. They call it different things now. Some schools still use that terminology, but I was an instructional assistant. I worked with high school kids, and basically the kids I worked with usually had learning disabilities or attention deficit disorders. And I would help them, accompany them to class, help them with their work. Some of the kids I would read to them and they would read along. I would collaborate with their teachers in modifying their homework if needed, and really just making sure that, the kids who had executive functioning issues, got everything they needed done by the end of the day. And it was great. And the school actually was undergoing a retrofit at the time I was working there. So I also worked with one student who was physically disabled. He had cerebral palsy, and he was in a wheelchair, and he wasn't very mobile. And the way they knocked down the school, I actually had to physically push him to places and then park his wheelchair and then hoist him over my shoulder and carry him up and down stairs and get him to his next class. So yeah, so when I went to law school, that was in my background, and LAUSD posted a job for a law clerk, and I wanted to work. I was older when I was a law student, so I interviewed, and I was the only person that they interviewed who knew what an IEP was. So I got the job, and the rest is kind of history.
Wow. So you started out LAUSD. Wow. Okay. So it sounds like your practice, I don't know how to ask this question. What's a typical day like as a special education attorney? What kind of cases, or who are you working with, I guess?
I'm primarily working with parents, and usually the issues involve services or placement for their kids. So, they either think their child isn't in the correct classroom, or they're not receiving the appropriate amount of services such as speech and language, occupational therapy, behavioral services, those kind of things. So, we look at the child's needs, and sometimes we go to IEPs and advocate there. But usually what I do is I file for due process, because usually by the time parents get to me, it's beyond the stage of something they can get accomplished at an IEP. So I initiate due process, which is litigation that's not quite the same as litigation in court. We're before an administrative body and it's a little less formal, but it can result in a trial. But usually it results in mediation, and we come together with the school district and eventually reach a resolution that everybody's a little bit happy with and a little bit unhappy with by the end.
I was a school psychologist for 10 years. I've been in private practice for 3, and I have never actually gone through due process with any of mine.
Me neither.
Right? But what is interesting to me is when I get called in now for IEEs, I feel like the relationship between the family and the district is just over, right? Like they are no longer communicating. We're not on the same page at all. Once they go through this process and we end in a settlement or we end in a whatever, do you feel like it continues to be contentious, or was it like, does it help the process? Does it help the student in the long run to do they get along better afterwards? I mean,
Yeah, it goes both ways. I mean, sometimes it's every year. There's some families and schools that every time there's an IEP, there's a due process that goes with it. But
Yeah.
most of the time, once you reach a resolution, you usually resolve a couple years worth of issues, and coming together in that way results in kind of moving forward. Because everybody's agreed to the solution. So now, okay, we have our student in a particular class, he's going to get these particular services, and everybody's agreed on that. So as long as both sides stick to the agreement, it usually gets better.
good. Yeah, I just wondered, for me, it feels like sometimes I'm even saying exactly the same thing that the district said, but they've lost all the trust with that district. And so hearing it from somebody else, they're like actually open to listening now, which makes me sad that it gets to that point. But I wondered, like, does it actually get better after that?
Yeah, I think that's a great thing about having someone who's independent come in, because I don't work with people who are going to say what I want them to say, or who even ask me what I want them to say. I tell them the situation. Look, we have a parent here who thinks that their student has dyslexia, and the school district doesn't think their student has dyslexia. You know what? Can you do that assessment? And the psychologist who's independent doesn't have an agenda. They don't have a boss telling them, hey, we don't have money to do whatever these parents are asking for. They get a fresh look, and sometimes they do agree with the school district. And if they do, then that helps the parent to kind of reconcile their feelings and move forward. And often they don't agree with the school district, and that helps the school district address the needs that the student has. So yeah, there's a big role for the independent assessment.
Yeah. Yeah. I think that's my favorite part of being an independent evaluator, is having come from the schools. Like there was always that pressure that, oh, we have too many kids that we're identifying, or we don't have the services needed for this kid, or all those extra pressures, or the parents are ticked off because, they don't agree, whatever. It was always felt like you were kind of damned if you do, damned if you don't. And then as an independent evaluator, you really get to just be non-biased. I always tease it. I'm just team kid. Whatever it is that the kid needs, that's what I'm gonna, whatever I feel like is the best course of action or whatever is what I get to recommend. And it's nice to not have all those extra people, I mean, I guess they could still not like me, but at the end, it doesn't matter. I'm moving on to the next one. So, okay. So you're located in Laguna Beach, and then you said you practice statewide all throughout the
Yes.
state. Okay.
I'm only licensed in California, so I only practice in California, but I do practice everywhere. And during COVID, the process that we deal with all moved to Zoom. So even mediations are now on Zoom, which has been great, because previously what would happen is the parents would have to go to the school district office and meet with the school district there. The judge from the state would come to do the mediation, but the school district is at their offices. So they're, you know, part of the problem is they would be distracted. They have people walking in and out. And the other part is it can be uncomfortable for a parent to be at the school doing, basically suing the school district while other parents are walking around, or, other teachers are walking by giving them the look like, what are you doing here? So it's been a very positive change in my opinion. The hearings are a little harder to run when you're on Zoom because you know, I'm a little bit older than some of these kids that are working now, so dealing with the technology of having all the evidence online, you know, was quite an adjustment. But I think overall it's been great, and it has allowed me to kind of expand where I can do cases anywhere, because anywhere in the state, because I just do them from this chair here.
Yeah. And I actually feel like IEP meetings are a lot more efficient online. There tends not to be as much chatter. You know, you just say what you need to say and answer whatever the question is. And there's not as much like well, there can't be side conversations unless it's on chat, I guess. So yeah, I agree. I like it. I like that I don't have to drive all over the place because I'm located in Bakersfield, but I serve a lot of surrounding areas.
Yes.
And it's nice to just click and I get to be wherever I need to be. So okay. So our listeners are mostly licensed educational psychologists. And so a big portion of a lot of our practices are completing independent education evaluations. So what would be like common scenarios where you would say we need to go get an IEE done? You know, like, or is there a test that you kind of litmus test as to decide who gets one versus where we would start elsewhere?
Yeah, I mean, there's the reason to get an IEE is usually because of a dispute, either about the eligibility category or a dispute about the services that a child needs. So it's usually one of those two things. And the idea is to get a fresh set of eyes to give some input on that. The you know, often, you know, a very common scenario is a district will label a student early on as having an intellectual disability, and the parents will think it's autism. And so that's a really good example of when it's good to have someone else come in and do some assessment there and see what's really going on. Another example is we'll often have kids labeled as emotionally disturbed, having an emotional disturbance, and it'll be more of a result of something like attention deficit hyperactivity disorder. So they're exhibiting kind of the symptoms of an emotional disturbance, but really the cause is this processing disorder that they have. So getting a fresh set of eyes there. And then also the way that a student is perceived also really affects the services they get, right? So
That's for sure.
some districts have classes that they label, this is the autism class, this is the mild moderate class. So, you know, if you're not diagnosed with autism, you don't get those extra behavioral services, that language-based instruction that a lot of kids with autism need. So, you know, that's usually when there's kind of that disconnect between what the parents are seeing and what the district's telling them, that's a great time to look at an IEE.
Mm-hmm. What's the process like for you when you request one? Like, is there do they just say it at a meeting? Is it in writing or?
Yeah, so usually you're going to ask for an IEE at an IEP, or you're gonna do it in writing usually by an email. And the district has only two responses according to the law that they can make. They can either give you the IEE, and by doing that, they send you their policy, and it's usually a list of, you know, usually they have a list of providers, and then they have a price, you know, kind of a price range. All those things are just to be taken as guidance. Sometimes the districts will act like this is dead set, you can only use these people, but that's not in compliance with the law. The law allows the parent to select somebody as long as they're qualified and they meet the district's criteria. So that's one roadblock that comes up often. The other response, besides granting the IEE and sending you that paperwork, is for the district to file against a parent for due process. That's to say, we've done an assessment, it's legally appropriate, we're not going to give you your IEE, we're filing for due process. If your district does this, it's a very aggressive district, because it's much more expensive for them to go to file for due process, to get a lawyer to do that. And if they eventually actually go through a hearing, it's way more expensive than actually paying to get a second look for the parent. So I think that's why the law is set up that way, is because they want districts to presumptively be granting these requests when parents are asking for an IEE.
I
But
want to give you a parent's number because she and she told me the story, and I believe that an independent evaluation was appropriate in this situation. And they gave her basically a prior written notice that just told her no. But they weren't filing for due process. They just said, we're not going to do it. So
a
there.
lot, yeah, that's a very common, I can phrase this two ways. It's either a common mistake or it's a common tactic, and it depends on who you're dealing with, right? So parents don't know the law usually, and a lot of times a district will get away with that. I will get files years later where I'll see that exact notice that you're talking about, a prior written notice, we're not giving you an IEE, but there's no filing for due process. And so if it's within the 2-year statute of limitations, I can pretty much automatically get them an IEE, because the provision of the law is they need to file for due process without unnecessary delay, is the exact language in the statute. So if they send that prior written notice and they don't file for due process, that in itself is a reason that they're going to have to do the IEE.
Fascinating. This is the same district that did hire me for an IEE and then never held the meeting. So they're special. They're very special. And I'm going to write down that this person gets your contact information, because yeah, there you go. Referral source right there. I'm sure you don't need them though, but all right. Jana, you look like you were going to say you were leaning in. I was catching the nonverbals.
Well, I have a question, but I don't know if you're going to ask it because I didn't bring
Go ahead.
questions up in front of me. But what is your process when a parent thinks that they may need an attorney? Like, what's it like when they reach out to you? What do they need? Do they request records, or do you do like a free, I'll look at this, or do you have a consult fee, etc.?
Yeah, so everyone does this a little bit differently. I'm a solo practitioner. I don't have any staff. So I answer my own phone, I do my own emails. So I mean, sometimes I'll pick up the phone and it's somebody I've never spoken with before. And if I'm not busy, I just talk to them. What's going on? They fill me in. I ask questions. If I need to see some documents, I'll ask them to send those over, and then we'll set up a more formal consultation. But I do all my initial consultations for free. And I try to structure my fees in a flat fee way so that parents know how much they're going to have to pay. I don't like to bill parents on an hourly basis because I don't want them to be afraid to call me, thinking that I've got a clock ticking on them, and that, they called me and now they're going to have to pay, half an hour for speaking to me. The way the law is set up is if you file for due process and you actually go all the way through with the hearing, and you prevail as a parent, then the district has to pay all of your attorney's fees. So there's incentive for the district to pay my fees at a mediation as part of the settlement, so that we don't go all the way through hearing. So I usually take some kind of small, and I say small, I mean small in comparison to other attorneys, but it's not small to parents. I mean, it's a substantial fee, but I also waive that in cases where I like to carry a certain amount of low income cases where people wouldn't be able to afford help, and I try to have some cases like that, and some cases that are paying, that kind of keeps the balance going for me.
You're good people, Brian.
Oh, thank you.
Yeah, you never know what you're gonna get with an attorney. Like, it kind of feels scary even for us, I think, just like
Yeah, and everybody handles it differently. And I'm not saying that the other way is bad. I mean, some people want they want a service, and they want to pay whatever it costs, and they're capable of doing that. But to me, it's people who have students with disabilities and are to the point where they're calling an attorney, they have enough stress in their lives that you want to kind of, you don't want it to add to that. You want to kind of try to help make it all go away. So I try not to have have me be the reason for more stress, and help as much as I can.
How big of a caseload do you maintain since you're a solo?
I try to keep, I don't like to have too many, because then I can't, I like to be able to communicate and keep up with everybody. So I generally run, I don't ever have more than 20, and I try to stay around 10 at a time. And it also depends on, the level of the case. Sometimes, if cases are super complicated and the districts are being stubborn and we're going to go to hearing, I need to slow down on taking anything new on until I can resolve those. But sometimes, you've got a bunch of, single issue cases that should be resolved, and you can kind of, move those through pretty fast. So yeah, I try to keep it kind of small. When I had someone working with me for a while, and we carried more when we had more of us to work, and I might go back to that. It's been getting busier lately, so I might look at getting somebody younger involved, and have them come aboard and help me out.
There you go. It's good. I had a question and it just left my brain, and I'm sure it was amazing. But how far have you taken a case? Like, have you gone all the way up to the high ranking courts, or do you usually get to settle before then?
Well, I always tell my clients about 98% of my cases settle either at mediation or sometime before the hearing. A lot of the districts will push parents all the way to the brink of hearing before they'll settle, because they want to see if the parents are actually going to go through with the hearing. They don't do that as much with me, because I've been to dozens of hearings and, had many cases decided. So they don't do that as much with me, but it'll still happen. But I've gone all the way through up to the Ninth Circuit on appeal. So the way the system works is, if you go through a due process hearing, the parent or the district can appeal to. I always go to federal court. You can go to state court. I prefer the federal court. And you have a modified trial at the federal court, where you submit the full transcript from the hearing. You have a chance to submit additional evidence, and then you write briefs, and then that judge makes a decision. They either uphold the decision, or they overturn it, or they overturn some parts of it, and then you can appeal that to the Ninth Circuit Court of Appeals. And I've done that a couple times. Those cases have all resolved once we got there. I've never had a decision issued from the Ninth Circuit, but I've gone there. And I've also done some injunctive relief cases where we go straight to the federal court. Those are usually cases that involve discipline, when the districts don't properly do the manifestation determination, and they're suspending kids that without their due process. So I've gone straight to federal court and gotten injunctive relief, and had stay put orders issued from the federal court in those kind of cases.
Wow. I'm glad I didn't work at those schools. Oh, sorry.
Why would you? Oh,
Go
sorry.
ahead.
What's the difference like between the federal court and the state court?
Well, the federal court is less crowded, really, and more efficient, and I'm more experienced in it. So since I'm so comfortable there, it's just better for me to go there. And because it's the law that we're practicing under is basically a federal law that has a state law that mirrors it. You have what's called federal question jurisdiction, so you can use the federal courts. I've had districts try to appeal in the state court, and I removed them to federal court, because that's something you can do. So yeah, I'm just more comfortable there.
So it's your choice what court you appeal to.
Yes.
All right. How do you, for going back to IEEs, how do you decide who you would recommend or who you feel is an appropriate evaluator? How do you help your parents find them?
Yeah, well, having done this for so long, I've met a lot of people, and I try to match people, first of all, and foremost is they need to be qualified, and I need to know that, they're going to do a good job for the parent. But I also kind of try to match personalities of my clients with the people that they're working with. Some people Some people need someone who's going to kind of hold their hand through the process, and not all psychologists want to do that. They want, some psychologists are more clinical in their delivery, and just, they do their testing, and they're very factual, and they don't want to be that kind of person. And some parents want that style. So I kind of look at the parent who I'm dealing with. I look at the child. A lot of the psychologists I work with kind of end up specializing in certain disabilities.
Okay.
A lot of psychologists really focus on autism. A lot of psychologists will focus on emotional issues, and then a lot focus on processing disorders. So kind of a combination. I find out, a good personality match, somebody who's qualified, and then somebody who really knows the area that the parents are concerned about.
I have another special education attorney that I've been working with periodically for a couple of other cases. And she always asks me whether or not she should ask a district for a neuropsych evaluation instead of a educational psych evaluation. And I always tell her that, well, I mean, I'm biased, right? Because I'm I'm an educational psych, but I'm like, well, we would be better apt at telling recommendations related to education code and, school-based programming, whereas a more clinical-based psychologist might not have that knowledge. So do you take that into account when you're advising people, or do you prefer a clinical, or do you have a preference?
Yeah, again, it's kind of a case by case, right? Because it always depends. Are we looking for kind of a roadmap of what the student needs? Or are we kind of looking at why the student needs things, right? So sometimes that neuropsych stuff can really help a parent to understand exactly what's going on with their child, and that, gives the district a little more understanding. But most of the psychologists I work with personally are um, educational psychologists.
That's the right answer, Brian. Just double checking that you were aware. Wasn't sure we were going to have to delete this episode, but we'll let it go to air now. So that's good. Yeah, it's funny because the lady that I've been chatting with, she's a new special education attorney, and we met through IEEs, but now she just asks me random questions, and she keeps coming back to the neuropsych one. And my answer was kind of similar to yours. I was like, well, it would answer questions for the parent, but it's not going to necessarily drive like eligibility, because that's not what they're trained on.
Right.
They got good stuff. I wouldn't knock their practice, but I don't know whether or not it'll be a good fit for what they need.
I mean, the hope is, like, if you're doing an assessment, even as a school psychologist, you're looking at it from the perspective that's going to help answer parent questions. And a lot of the assessments that we have coming through our doors for IEEs, when we look at the, like the academic, like it could be a beautifully written report, but when you look at, for example, like the academic section of the report, which obviously is probably not done by a school psychologist, right? But if the question is, does this kid have a learning disability? And all the assessment does is describe what the test was with like a paragraph this big, but all it is templated language that says 86, low, average, and those are the only words that they change for every kid, then how could a parent possibly know, what's going on? I mean, this is kind of off topic, but just made me think, like, parents think like, oh, I need a neuropsych. They don't really need a neuropsych, but they do want to know why their kid performed the way that they did and how a team came to this decision through the report. And it's not just about the test scores. It's about the process of how they, got there. So I think a lot of the times when we're doing IEEs, we're just giving them more information and giving the school more information to help them better understand, is this a learning disability or whatever it is, but just that deeper dive.
Yeah.
Absolutely. And I know exactly what you're saying about those reports. Sometimes, and I feel for the school psychologists, because a lot of them have a workload that is unmanageable, and it's not their fault that they're giving too much work. And so they're using templates, and they're cutting and pasting. And sometimes I get reports that have the wrong kid's name in them. And to the psychologist, it's just a typo, but to the parent, I mean, that's you're evaluating my kid and you're giving me a report and it's got someone else's name in it. I mean,
Yeah.
and I don't think they understand how offensive that can be at times, and
Mhm.
and so it leads the parent to question, well, is this paragraph even about my kid, right?
Right.
So yeah, it's when you have that someone who can take a little more time and really get into it, I think that gives the parent a lot more trust.
We have had a couple of guests on the show so far that are bigwigs in our local or state association of school psychologists, and LEPs, licensed educational psychologists, we're under their umbrella, but we're also under the Board of Behavioral Sciences umbrella. So there was Larry P has come out long time ago. And now the California Association has received guidance from the Board of Education, and it's kind of super vague, but basically maybe we could test African Americans with a IQ test. So I've asked this question to people who are school psych administrative people, and they have all like slapped my hand and said, how dare you think about giving an African American a cognitive test? Because we have to follow whatever the district procedure is when we're doing an IEE. And I get that to an extent, but as an attorney who would be representing families, could you ever see it being a hindrance for a licensed educational psychologist providing an independent education evaluation and providing a cognitive assessment for an African American student? I just love your opinion. I know this is just like whatever.
Yeah, this is such a sensitive topic, but my opinion on this is really, if you're not working for a school district, you're not bound by that case, right? So you can do it. And I really think that's up to the parent to make an informed decision. So I would say, as the independent psychologist, you explain the reasoning of Larry P to the parent and say why, what do you think? If it's not offensive to the parent, if this is information they think would be helpful to them, I don't see harm in doing it. Now, to just take the IEE on and go ahead and do that without talking to the parent about those issues, that's a serious problem, I think. But if you discuss it with the parent and the parent's on board and they're informed and they give consent, I don't see a harm in it.
Yeah, I've had so many, as a school psychologist, so many evaluations where parents were actually offended that I didn't do the assessment and having to explain, I mean, that it's an incredibly old law, and but I still have to be bound by it. And so there's a lot of school districts right now that are, of course, hesitant because no one wants to be the first one to get in trouble or not get in trouble, right? And so in my opinion, I was like, well, shoot, we're the perfect people to do this because we are independent. And but I just decided to throw that question at you because you're here and you're fun. So I'm like, I'll torture you a little bit more.
I will also say, Bethany, that I've had some offline conversations with other people who will go unnamed.
Put it in the chat. Oh, just kidding.
I mean, just we've been kind of toying with this because you are independent. You don't work for the school district. Like, you're being funded by the school district, but they don't really have jurisdiction over what you do in your practice. Now, whether they consider those test scores or not, I think is up to them. But like, I think about it like, what if there was a clinical psychologist doing the IEE, which we used to have tons of, right? I don't know what kind of school district, well, I don't know what school districts are doing anymore. There are probably some clinical psychologists still doing IEEs somewhere, right? Neuropsychs. Do you think that they're going to ask the district, hey, do you mind if I do a cognitive test on this student? No, they're not going to ask that, and what would happen if do you think a school district would say to them, oh, and by the way, don't do a cognitive test with this African-American student? Like, what do you think they would say? Like, what? That's not how right? So it's almost like because we're LEPs, because we still feel this like like we're under this umbrella of the school district. We're really not, but we are, but we're not.
Yeah.
So I've had this
Yeah.
continued conversation, and people, who I've been talking with, we've been kind of on Team Bethany with this one a bit,
I'm gonna make a shirt.
Yeah. So,
Yeah,
I don't know, like, I don't know what I would do the next time that came up for me in my practice, but
I think I'm gonna go. I mean, I appreciate Brian's input though, like having that conversation and laying it out and making sure that we're all on the same page. Because truly, I would only do it because I felt that it gave me a better picture of the student and their needs, right? But I understand the constraints that our school psych buddies have, but their districts are not allowing them to do it. But to me, I'm like, well, then licensed educational psychologists are the perfect ones to start the trend. Yeah, but anyways, I have one final question because I do want to respect your time, Brian, because we're so glad that you're here with us. But can you share with us a story or an example of when you saw an IEE make really a significant difference in the life of a student?
Oh, absolutely. And kind of what we started off talking about is why do you look at IEEs? I've had, a couple students who were diagnosed really early by a school district as having intellectual disabilities and just kind of stuck in that, class where they're not expected to make much progress and, had an IEE and, wow, this student actually has autism and speech and language problems that can be addressed. And, um, you know, years later, the cognitive test that was a 76 is 105 because the student had ABA therapy, they had behavioral services, they had a language-rich classroom that they were engaged in. So, that's always been the most powerful thing, I think, is when you take that, that expectation of no progress, from a kid who's only 3 years old, and you change that to, wow, we can actually address the student's needs, and it's not actually an intellectual disability, it's autism or it's something else. And that's always been the most powerful. Other times, it is, I think in the area of behavior analysis, I've always felt like that's always a strong area for an independent evaluation, because sometimes the people in the school get so involved in their own program and what's going on in their school and their classroom that they don't step back and see the big picture. So when you have someone come in and actually see, wow, what's really going on here is you're actually triggering the kid by what you're doing.
Yeah.
And you get that independent set of eyes, and I've had actually teachers be thankful that this independent person actually pointed this out to them and changed the behavior plans so that we were encouraging a positive reaction from a student rather than doing things that are directly triggering the behaviors that we're trying to avoid. So those are probably the two biggest areas that I've seen.
I love it. Well, Brian, thank you so much for being on the show. You can come back anytime. I think
Great.
we could just give you question after question after question, I have a feeling. So, but I just want to say thank you for being here and for giving us some of your time. And I have several clients that I'm going to send your way.
Well, thank you. It's been a pleasure.
Thank you for listening to the Empower LEP Collaborative Podcast. Episodes can be found at empowerlepcollaborative.com. If you liked what you heard, please leave us a 5-star rating and review on your favorite podcast player. If you'd like to be a guest on our show, or if you have any questions for us, don't hesitate to connect. We would love to learn more. Jana can be found at jana@empowerlep.com, and Bethany can be reached at bethany@lepcollaborative.com.